My name is Daniel Vaswani, and I'm the lead attorney at Virtuoso Criminal and DUI Lawyers. Today, I'm going to talk about various things involving domestic violence. In California, the crime of domestic violence is actually a very broad crime. And when I say that, what I mean is that in order to have committed an act of domestic violence, there has to be some sort of overt act on behalf of a person who's in a qualifying relationship with another person. Now, keep in mind, when I say a qualifying relationship, there are some specific definitions that are set forth in both the California Penal Code and the California Family Code. Specifically, California Penal Code Section 13700B, and the Family Code lays everything out in Section 6211. And what it says is that in order to be in a qualifying relationship, there are a series of potential relationships that actually fall within the purview of the law. The first one is obviously someone who is the spouse of another person. That means that you have a formal relationship under law, or even often an informal relationship, a partner, a domestic partner. Also, you could have a domestic violence incident with someone that is a cohabitant, your fiance, someone that you've had a previous living relationship with, a current living relationship with, a common or shared child. So it can mean a series of potential people. Even if you co-parent a child with another person who happens to not live in the same location in which you live, if there is an overt act with that person, that could be an act of domestic violence. Now, the reason why the legislature has drafted the qualifying relationship as something quite a bit broader than what you'd normally expect is because the Penal Code institutes specific requirements that must be completed in order to complete what would otherwise be a sentence associated with a domestic violence act. For more information, please like this video, subscribe, or reach us by phone, 8336-NO-JAIL.